What are the benefits of a 1031 exchange Delaware Statutory Trust, DST? If you are selling investment real estate and racing the 45-day clock, a Delaware Statutory Trust might be the backup plan that keeps your 1031 exchange alive. A 1031 exchange lets you sell real property held for investment or business use and reinvest into like-kind real property while deferring capital gains tax if you follow Internal Revenue Code Section 1031 rules. In a deferred exchange, you must identify replacement property in writing within 45 days after closing the sale of the relinquished property. You must acquire the replacement property by the earlier of 180 days after the sale or the due date of your federal income tax return for that year, including extensions. A qualified intermediary holds the sale proceeds during the exchange period, and you cannot receive the funds directly or indirectly without risking a taxable sale. A Delaware Statutory Trust, or DST, is a legal entity formed under the Delaware Statutory Trust Act that holds title to income-producing real estate. Instead of buying and managing a replacement property yourself, you buy a beneficial interest in the trust and receive a fractional share of the underlying real estate for federal tax purposes. The IRS confirmed in Revenue Ruling 2004-86 that a properly structured DST holding rental real estate can be treated as a trust for federal tax purposes, which helps a DST interest qualify as like-kind replacement property under Section 1031. In practical terms, a DST sponsor acquires and finances the property, sells beneficial interests to investors, and a trustee manages the property on behalf of investors. You receive your pro rata share of rental income distributions, depreciation deductions, and proceeds when the property is eventually sold, without managing tenants, leases, or maintenance. One major benefit is tax deferral, because a qualifying exchange into a DST can defer capital gains tax and depreciation-related gain if you follow the exchange rules and avoid taxable boot. When you sell investment real estate at a profit, part of the gain may be taxed at long-term capital gains rates, and you may also face the net investment income tax and unrecaptured Section 1250 gain tied to prior depreciation. A DST-based exchange can defer federal recognition of those gains when the replacement interest qualifies and the exchange is properly executed. Another potential benefit is estate planning, because if an investor dies while holding a DST interest, heirs generally receive a stepped-up basis to fair market value at the date of death, though exceptions can apply. DST ownership can also provide ongoing depreciation deductions allocated to each investor based on their individual tax basis from the exchange. Beyond taxes, DSTs are designed for passive ownership, with professional management handling property operations while investors receive distributions and tax reporting tied to their beneficial interest. DST offerings may give access to institutional quality real estate such as Class A apartments, medical office buildings, distribution centers, net leased retail, and industrial warehouses that can be difficult for individual buyers to acquire alone. DSTs may also help diversify, because you can allocate exchange proceeds across multiple offerings in different property types and markets to reduce concentration risk. DSTs can help with timing because they are often pre-packaged, already acquired, and ready for investor participation, sometimes allowing closings within a few business days after commitment. That speed can be especially helpful late in the exchange window, although you still must coordinate documentation and your qualified intermediary to remain compliant. DST interests can also serve as a backup identification under the three-property rule, which can protect your exchange if another acquisition fails. Compared to a tenancy in common structure, a DST generally provides less investor control, while TIC ownership can require unanimous consent for major decisions and can involve more complicated financing. Compared to direct ownership, a DST can reduce day-to-day management burdens, while direct ownership offers full control but also full responsibility and potential personal guarantees. DSTs have important restrictions because the trust must remain a passive investment vehicle, and too much operational power can risk the DST being treated as a business entity instead of a trust for federal tax purposes. IRS guidance warns against trustee powers like acquiring new property, renegotiating leases, refinancing the loan, investing cash for market profit, or making more than minor improvements that are not legally required. DSTs also carry risks, including illiquidity because there may be limited or no secondary market and investors often must hold for the full life of the offering. Another risk is lack of investor control because you generally cannot direct operations, approve lease changes, influence capital improvements, or control sale timing. Tenant and market conditions can reduce distributions and investment value, and distributions are not guaranteed. Sponsor quality matters, so investors are advised to review the private placement memorandum and disclosed risk factors before committing exchange proceeds. International exchanges have separate rules because United States real property is not like kind to real property located outside the United States under Section 1031(h). Because DST interests are offered through sponsors and commonly distributed through broker-dealers and registered investment advisors, evaluating the offering terms and documents is a key step. A 1031 exchange lawyer can help you align DST selection with the exchange deadlines and documentation requirements. A qualified attorney can also review private placement materials, sponsor track record disclosures, and property-level details so you understand the trade-offs before you invest. Sishodia PLLC describes guiding investors through the exchange process, including contract review, qualified intermediary coordination, and DST offering evaluation. Natalia Sishodia is identified as the managing partner, and the law firm notes experience with New York real estate transactions and 1031 tax-deferred exchanges for domestic and international clients. If you need help weighing DSTs against TICs or direct ownership, a 1031 exchange attorney can walk through control, timing, and risk considerations tied to your goals. For Manhattan investors trying to preserve deferral while moving toward passive ownership, a lawyer can also help confirm whether a DST structure fits the exchange and investment plan. Call Sishodia PLLC to discuss 1031 exchange options and DST considerations. Sishodia PLLC is located at 600 3rd Avenue 2nd floor, New York, New York, 10016, United States, and you can reach the law firm at 833-616-4646.